Okay, welcome to our picture point and lecture on civil liberties. I'm Mr. L, and I'll be taking you through the content on this section. So we're going to be looking at the constitutional protections for your rights and liberties, especially as it relates to the First Amendment, freedoms of speech, press, religion, assembly, and petition, and also the criminal protections in the Bill of Rights, especially in the 4th, 5th, 6th, 8th Amendments. We'll also look at the right to privacy, right to die. This has got one of my favorite units, and it's got a smattering of a whole bunch of stuff in it. It's not all inclusive. We'll talk about a bunch of stuff in class as well, but this gives you a really good background in terms of kind of giving you an oversight, I guess you would say, to what we're going to cover here. So I'm going to full screen this and get us going. So, hopefully you can kind of look at this. Actually, I don't think I want to full screen that. So, actually, we'll just entire page it is what we'll do. Okay, great. So, when you hear someone say the land of the free, when you're asked, or when you hear someone say that, what makes the United States distinctive? What makes Americans commonly say that this is a free country? We've long believed that limits on the power of government are an essential part of what makes this country free. Remember all the way back to our very first unit together, that restraints on the actions of government against individuals are generally referred to as civil liberties. The first 10 amendments to the U.S. Constitution, the Bill of Rights, place such restraints on the national government. Now, of these amendments, none is more famous than the First Amendment, which guarantees freedom of religion, speech, press, petition, and assembly. Now, most other democratic nations have laws to protect these and other civil liberties, but none of the laws is quite like the First Amendment. Take this issue of hate speech. What if someone makes statements that stir up hatred toward a particular race or another group of people? Now, in Germany, where memories of Nazi anti-Semitism remain very much alive, such speech is unquestionably illegal. But in the United States, that issue is not very clear. Courts have often extended constitutional protections to this kind of speech. Now, in this unit, we're going to describe the civil liberties that are provided by the Bill of Rights and some of the controversies that surround them. This is a very controversial section. Together, we're going to look at the First Amendment, including the Establishment Clause, which states that the United States government may not establish a religion, which today that kind of means more endorsement rather than establishment. We'll also discuss the right to privacy, which is really at the heart of one of the fundamental issues in modern American politics today, abortion. And we'll also look at the rights of defendants in criminal cases. So as you go through this picture point with me in this lecture, bear in mind that the Bill of Rights, like the rest of the Constitution, is a fairly brief document. The framers set forth broad guidelines, leaving it up to the courts to interpret constitutional mandates and to apply them to the specific situations. Judicial interpretations shape the true nature of civil liberties and rights that we possess. But because judicial interpretations change over time, so do our liberties. What you're going to find out in this section is that there have been many conflicts over the meanings of simple phrases such as, what does freedom of religion or freedom of the press really mean? Think about recently the war on terror and how it's had an impact on what it is to be free in America. Now, to understand what freedoms we actually have, we need to examine how the courts, and particularly the United States Supreme Court, has resolved some of these conflicts. One important conflict was over the issue of whether the Bill of Rights in the federal Constitution limits the powers of state governments as well as those of the national government. Now, many citizens do not realize that, as originally intended, and many students especially, the Bill of Rights only limited the powers of the national government. At the time the Bill of Rights was ratified, there was little concern over the potential of state governments to curb civil liberties. For one thing, state governments were closer to home and easier to control. And for another, most state constitutions already had their own bills of rights. Rather, the fear was of the potential tyranny of the national government. The Bill of Rights begins with the words, "Congress shall make no law," but it says nothing about states making laws that might abridge citizens' civil liberties. In 1833, in a case called Barron versus Baltimore, the United States Supreme Court held that the Bill of Rights did not apply to state laws. We mentioned that most states had bills of rights. These Bill of Rights were similar to the national one, but there were some differences. Furthermore, each state's judicial systems interpreted the rights differently. Citizens in different states, therefore, had different sets of civil rights. It wasn't until after the 14th Amendment was ratified in 1868 that civil liberties guaranteed by the national Constitution began to be applied to the states. Now, Section 1 of that amendment provides for the following: no state shall deprive any person of life, liberty, or property without due process of law. Now, there's no question that the 14th Amendment applied to state governments. But for decades, courts were reluctant to define the liberties spelled out in the National Bill of Rights as constituting due process of law, which was protected under the 14th Amendment. Now, there are a wide variety of reasons for that. If you think back to your federalism section, remember the idea of dual federalism and the federal government staying to their own area and state governments staying to theirs. But it's not until 1925, in a case called Gitlow versus New York, did the United States Supreme Court hold that the 14th Amendment protected the freedom of speech guaranteed by the First Amendment to the Constitution. Only gradually, and never completely, did the Supreme Court accept what's called the incorporation theory, the view that most of the protections of the Bill of Rights are incorporated into the 14th Amendment's protection against state actions. Now, this table what I've described as Table 4.1, shows the rights that the court has incorporated into the 14th Amendment and the case in which it first applied each protection. Now, as you can see in the table, in the 15 years following the Gitlow decision, the Supreme Court incorporated into the 14th Amendment the other basic freedoms of press, assembly, petition, and religion, which were guaranteed by the First Amendment. Now, these and later Supreme Court decisions listed in this table have bound the 50 states to accept for their citizens most of the rights and freedoms that are set forth in the U.S. Bill of Rights. But there are some, even today, that have never yet been incorporated. For example, the Fifth Amendment's protection or requirement for what's called a grand jury, which we'll get into a little bit later. let's kind of look at some more of these rights and freedoms, starting with the freedom of religion. But before I go on to the next slide, look through this list, and you don't have to know all of them, but you definitely need to know the first, and just familiarize yourself with the time frame involved of how long it takes the court to actually say that some of these things are that states must follow these provisions in the Bill of Rights. Keep in mind, when we think about the idea of civil liberties, primarily it's states that are violating civil liberties, and it's states pushing the envelope rather than the federal government. And so if you look down this list, and especially you get into the 1960s here, and you're looking at criminal protections, these are states that are often doing this and not the federal government.
Miss Lucas, if you're in the building, please come to the office. Miss Lucas.
Now, in the United States, freedom of religion consists of two main principles as they are presented in the First Amendment. First, you have the Establishment Clause, which prohibits the establishment of a church that is officially supported by the national government, therefore guaranteeing the division between church and state, although you don't find those words church and state in the Constitution anywhere. The Free Exercise Clause constrains the national government from prohibiting individuals from practicing the religion of their choice. But these two precepts can inherently be in tension with each other. For example, would prohibiting a group of students from holding prayer meetings in a public school classroom infringe on the student's right to free exercise? Or would allowing the meeting amount to an unconstitutional government support for religion? So it's a very thin double-edged sword here. So I'm going to give you some scenarios here and we'll kind of go through them. The First Amendment to the Constitution states that Congress shall make no law respecting an establishment of religion. And in the words of Thomas Jefferson, the Establishment Clause was designed to create a wall of separation between church and state. Perhaps Jefferson was thinking about religious intolerance and that many of the first colonists were trying to escape from. Many of these colonies were established by those groups, if you remember back to our Origins of Government section. But nevertheless, these early colonists were still quite intolerant, though, of religious beliefs that didn't conform to those held by the majority of citizens within their own communities. Jefferson undoubtedly was also aware that state churches or denominations were the rule. Among the original 13 colonies, 9 of them had official churches, including here in Virginia, where the Episcopal Church was the official church of the state. As interpreted by the United States Supreme Court, the Establishment Clause in the First Amendment means at least the following. Neither a state nor the federal government can set up a church. Neither can pass laws with which aid one religion, aid all religions, or prefer one religion over another. Neither can force nor influence a person to go to or to remain away from church against his will, or force him to profess a belief or disbelief in any religion. No person can be punished for entertaining or professing religious beliefs or disbeliefs, for church attendance or non-attendance. No tax in any amount, large or small, can be levied to support any religious activities or institutions, whatever they may be called, or whatever form they may adopt to teach or practice religion. Neither a state nor the federal government can openly or secretly participate in the affairs of any religious organizations or groups, and vice versa. That's from Everson versus Board of Education in 1947. Now, the Establishment Clause covers all conflicts about such matters, such as the legality of giving state and local government aid to religious organizations and schools, allowing or requiring school prayers, teaching evolution versus intelligent design, posting the Ten Commandments in schools or public places, and discriminating against religious groups in publicly operated institutions. The Establishment Clauses mandate that government can neither promote nor discriminate against religious beliefs, though raises some very difficult questions for us. In contrast to the United States, many other nations have established churches or religions. So the United States is fairly unique in this, that we try to separate our church from our political institution. Throughout the United States, property owners, except religious, educational, fraternal, or similar nonprofit institutions, must pay property taxes. Now, a large part of the proceeds of such taxes go to support public schools. But fully 13% of school-aged children attend private schools, mine included, of which 80% have religious affiliations. Mine don't. In many cases, the United States Supreme Court has tried to draw a very fine line between permissible public aid to students in these schools and impermissible public aid to religion. These issues have arisen most often at elementary and secondary levels. In 1971, in a case called Lemon versus Kurtzman, the court ruled that direct state aid could not be used to subsidize religious instruction. The court in the Lemon case, though, gave its most general statement on the constitutionality of government aid to religious schools, stating that the aid had to be secular or non-religious in aim, that it could not have the primary effect of advancing or inhibiting religion, and that the government must avoid an excessive entanglement with religion. All laws under the Establishment Clause are now subject to this what's called three-part Lemon test. But how the test is applied has varied over the years. In a number of cases, the Supreme Court has held that the state programs helping church-related schools are unconstitutional. The court has denied helping church-related schools get state reimbursement for things like field trips and developing achievement tests. But in a series of other cases, the Supreme Court has allowed states to use tax funds for things like lunches and textbooks, diagnostic services for speech and hearing problems, standardized testing, computers, transportation, as well as special education services for disadvantaged students. So the line here is very, it's a very gray area. Now, an ongoing controversial issue concerning the Establishment Clause has to do with school vouchers, which is now on your screen. One solution to the problem of poor educational performance has been for state and local government to issue school vouchers. And these vouchers represent state-issued funds that then can be used to purchase education at any school, public or private. Now, at issue is whether or not voucher programs violate the Establishment Clause. In 2002, the United States Supreme Court held that a voucher program in Cleveland, Ohio did not violate the Establishment Clause. The court concluded that because the vouchers could be used for public as well as private schools, the program did not unconstitutionally entangle church and state. The court's 2002 decision was encouraging to those who support school choice, whether it takes the form of school vouchers or tuition tax credits to offset educational expenses in private schools. Today, 13 states in the District of Columbia allow public funds to be used for private education, although the District of Columbia's program is waivers depending on who's president or who's controlling Congress. So in 2008, 2009, Congress withdrew its constitutional protection for the District of Columbia or its school voucher program. And then when Republicans regained House control, they reinserted funding for DC's school voucher program. 6 states in the District of Columbia have small-scale voucher programs for a limited number of students, and 7 states offer tuition tax subsidy programs. At the national level, President George W. Bush urged Congress to pass legislation that would allow public funds to be used for education in either a private religious school or a public secular institution. Nevertheless, though, some state courts, such as those in Florida and Colorado, have held that school vouchers do violate their state constitutions, and the nation's lawmakers still do remain divided on the issue, with many Democrats with support from the teachers' unions being solidly against school vouchers, while many Republicans and school reform-minded individuals are solidly for them. Do states, though, have the right to promote religion in general without making any attempt to establish a particular religion? That's the question that's really raised by school prayer and was the precise issue presented in 1962 in Engel versus Vitale, what's called the so-called Regents' Prayer case in New York. The State Board of Regents in New York had suggested that a prayer be spoken aloud in public schools at the beginning of each day. The recommended prayer went like this: Almighty God, we acknowledge our dependence upon Thee, and we beg Thy blessings upon us, our parents, our teachers, and our country. Now, just from my perspective, I wish somebody would be praying for me on a regular basis. And maybe you are, but I'd like to hear it every once in a while. But such a prayer was implemented in much of the New York City public school system. Now, the parents of a number of students, though, challenged the action of the Regents' board, maintaining that it violated the Establishment Clause of the First Amendment. And at trial, the parents lost their case. But at the Supreme Court, they won, with the court ruling that the Regents' action was unconstitutional because, quote, the constitutional prohibition against laws respecting an establishment of religion must mean at least that in this country it is no part of the business of government to compose official prayers for any group of the American people to recite as part of a religious program carried on by any government, end quote. The court's conclusion was based in part on the historical fact that government established religions and religious persecutions, they often go hand in hand. In Abington School District versus Shemp, the Supreme Court outlawed officially sponsored daily readings of the Bible and recitation of the Lord's Prayer in public school. Now, although the Supreme Court has ruled repeatedly against sponsored prayer and Bible reading sessions in public schools, other means for bringing some form of religion's expression into public education has been often attempted. In 1983, the Tennessee legislature passed a bill requiring public school classes to begin each day with a minute of silence. Now, Alabama had a similar law. In 1985, in Wallace versus Jaffrey, the Supreme Court struck down as unconstitutional the Alabama law authorizing 1 minute of silence for prayer or meditation in all public schools. Applying the Lemon test, the court concluded that the law violated the Establishment Clause because it was an endorsement of religion lacking any clearly secular purpose. But think about our moment of silence in Virginia. What can we learn from that? Well, since then, Lower courts have interpreted the Supreme Court's decision to mean that states can require a moment of silence, such as we do, if they make it clear that the purpose of the law is secular and not religious, which is exactly what Virginia did. So courts have also dealt with cases involving prayer in public school outside of the classroom, particularly prayer during graduation ceremonies. In 1992, in Lee versus Wiseman, the United States Supreme Court held that it was unconstitutional for a school to invite a rabbi to deliver a non-sectarian prayer at graduation. But the court said nothing about students organizing and leading prayers at graduation ceremonies or at other school events. And these issues continue to come before courts all the time. A very contentious question has been the constitutionality of these student-initiated prayers, say before sporting events, such as football games. In 2000, the Supreme Court held that while school prayer at graduation did not violate the Establishment Clause, students could not use a school's public address system to lead prayers at sporting events. Now keep in mind that a lot of these things happen, and they happen simply because people, no one there is going to take the time to prevent them from happening by going to federal court. Now, in spite of the court's ruling, students, especially in this often happens in much further southern states in the middle of the Bible Belt, like in Texas, they continue to pray over school public address systems and so forth, pretty much ignoring the court's directive. In other areas, the court's rules skirted by the avoidance of the use of the public address system. For example, one school system in North Carolina, a pregame prayer was broadcast over a local radio station and heard by the fans who took their radios to the game expressly to hear the radio announcers. So it wasn't broadcast on the local thing, but it was broadcast over the airwaves. It seemed like to me that that would be more of a violation, but apparently not. A church-related issue is whether the Ten Commandments can be displayed in public schools, or on any public property for that matter. In recent years, a number of states have considered legislation that would allow or even require schools to post the Ten Commandments in their school buildings. Supporters of what they call the Hang Ten movement claim that school children are just not being taught the fundamental religious and family values that frame the American way of life. They argue that the Ten Commandments are more than just religious documents. The commandments are also secular in nature because they constitute a part of the official and permanent history of American government. But opponents of such laws claim that they are an unconstitutional government entanglement with the religious life of citizens. But still, various Ten Commandments installations have been found to be constitutional. For example, the Supreme Court ruled in 2005 that a granite monument on the grounds of the Texas state capitol that contained the commandments was constitutional because the monument as a whole was secular in nature. But in another 2005 ruling, the court ordered that displays of the Ten Commandments in front of two Kentucky courthouses be removed because they were overtly religious. Much of the difference had to do with the fact that you're typically not forced to go to the court, to the Capitol grounds, but yet you are forced to go to the courthouse for some reason. So that's kind of the difference there. The Ten Commandments controversy took an odd twist too in 2003 when in the middle of the night Alabama Chief Justice Roy Moore installed a 2.5-ton granite monument featuring the commandments in the rotunda of the state courthouse. When Moore was ordered by a federal judge to remove the monument, the Alabama Court of the Judiciary was forced to expel him from the judicial bench because he refused to comply with the order. The monument was later then wheeled away to a storage room, never to be seen again. Bizarre. For a bunch of decades, too, one of the big topics was the forbidden teaching of evolution. Certain religious groups, particularly in southern states, opposed the teaching of evolution in schools. To these groups, evolutionary theory directly counters the religious belief that human beings didn't evolve but were created fully formed, as described in the biblical story of creation. Now, state and local attempts to forbid the teaching of evolution, however, have not passed constitutional muster in the eyes of the United States Supreme Court. For example, in 1968, the Supreme Court held in Epperson versus Arkansas that an Arkansas law prohibiting the teaching of evolution violated the Establishment Clause because it imposed religious beliefs on students. So therefore, the state of Louisiana and the wise legislature that they have passed a law requiring the teaching of the biblical story of creation alongside the teaching of evolution. But in 1987, in Edwards versus Aguillard, the Supreme Court declared that this law was also unconstitutional, in part because it had as its primary purpose the promotion of a religious belief, therefore violating the Establishment Clause. But nevertheless, state and local governments, around the country, particularly in the so-called Bible Belt, continue their efforts against teaching of evolution. The Cobb County school system in Georgia attempted to include a disclaimer on its biology textbooks that proclaimed, quote, evolution is a theory, not a fact regarding the origin of living things, end quote. But a federal judge later ruled that the disclaimer stickers must be removed from the textbooks. Other school districts have considered teaching what's called intelligent design as an alternative explanation of the origin of life. I think that's on the next screen here, yeah. Let me full screen that for you. Whoops, not that one. How about entire page? There we go. In 2005, the Kansas State Board of Education rewrote its science standards to implement the teaching of intelligent design in Kansas schools. When a new board was elected in 2006, though, they reversed the decision. Proponents of intelligent design contend that evolutionary theory has a bunch of gaps in it that can only be explained by the idea that there's a intelligent creative force that's guiding the hand of evolution, and that creative force has to be God. Federal courts take up this issue of intelligent design starting in 2005, and actually in the previous year, the Dover Area Board of Education in Pennsylvania had voted to require the presentation of intelligence design as an explanation of the origin of life. But in December of 2005, a U.S. District Court ruled that the Dover mandate was unconstitutional. Judge John Jones III, appointed in 2002 by President George W. Bush, issued a 139-page decision that criticized intelligent design theory in depth. All of the school board members who endorsed intelligent design were then later voted out of office, and the new school board declined to appeal the decision. Now, another controversy in the area of church and state relations concerns religious speech in public schools or universities. For example, in Rosenberger versus the University of Virginia, the issue was whether the University of Virginia violated the Establishment Clause when it refused to fund a Christian group's newsletter, but granted funds to more than 100 other student organizations. The Supreme Court ruled that the university's policy unconstitutionally discriminated against religious speech. The court pointed out that the funds came from student fees, not general taxes, and were used for the neutral payment of bills for student groups. Later, the Supreme Court reviewed a case involving a similar claim of discrimination against a religious group called the Good News Club. The club offered religious instruction to young school children, and the club sued the school board of a public school in Milford, New York, when the board refused to allow the club to meet on school property after the school day ended. The club argued that the school board's refusal to allow the club to meet on school property when other groups such as the Girl Scouts and the 4-H Club were permitted to do so amounted to discrimination on the basis of religion. And ultimately, the Supreme Court will agree with them, ruling in Good News Club versus Milford Central School that the Milford School Board decision did violate the Establishment Clause. Now let's switch gears a little bit, talk a little bit about free exercise. The First Amendment constrains Congress from prohibiting the free exercise of religion. But does free exercise mean that no type of religious practice can be prohibited or restricted by government? Certainly a person can hold any religious belief that he or she wants, or a person can have no religious belief if they want. However, but when religious practice can work against public policy or personal good, then government can take action. For example, regardless of a child or parent's religious beliefs, government can require certain types of vaccinations. Additionally, public school students can be required to study from textbooks chosen by school authorities, even if a parent says it violates our religious beliefs. The extent to which government can regulate religious practices has always been a subject of controversy. So before we really get into this, remember, belief, always protected. Action, not always protected. So that's the important thing. Belief, yes. Action, no. The extent to which for this, though, starts in 1990. Of course, free exercise clause cases predate this quite a bit, but the modern cases that we want to talk about start with Oregon versus Smith, which in Oregon versus Smith, the United States Supreme Court ruled that Oregon could deny unemployment benefits to two men who were drug counselors who had been fired for using peyote, which is an illegal drug, in their religious services. Now, the counselors argued that peyote was part of the practice of a Native American religion and that their forefathers had been using it for generations. Many criticized, though, this decision as it was going too far in the direction of regulating religious practice. So therefore, in 1993, Congress responded by passing the Religious Freedom Restoration Act, or the RFRA. And one of the specific purposes of the act was to overturn the Supreme Court's decision in Oregon versus Smith. The act required national, state, and local governments to accommodate religious conduct unless the government could show that there was a compelling reason not to do so. Moreover, if the government did regulate a religious practice, it had to use the least restrictive means possible. Some people believe that the RFRA, though, went too far in the other direction. It accommodated practices that were contrary to the public policies of state governments. Proponents of states' rights complain that the act intruded into an area traditionally governed by state laws and not by the federal government. In 1997, in City of Bourne versus Flores, the Supreme Court agreed and held that Congress had exceeded its constitutional authority when it passed the RFRA. According to the court, the act's sweeping coverage ensured its intrusion at every level of government, displacing laws and prohibiting official actions of almost every description and regardless of subject matter. So therefore, declared to be unconstitutional. Let me go back to that. Not quite done with that slide yet. Courts have repeatedly held that the United States government at all levels must remain neutral on issues of religion. In Good News Club decision that I talked about earlier, the Supreme Court ruled that state power is no more to be used to handicap religions than it is to favor them. But nevertheless, by overturning the RFRA, the court cleared the way for public schools to set regulations that, while ostensibly neutral, effectively limited religious expression by students. One example is a rule banning hats, which has been instituted by many schools as a way of discouraging the display of gang insignia. This rule has been interpreted as barring yarmulkes, the small caps worn by strictly observant Jewish boys and men. The national government has found a new way to ensure that public schools do not excessively restrict religion, though. To receive funds under No Child Left Behind in 2001, schools must certify in writing that they do not ban prayer or other expressions of religion as long as they are made in a constitutionally appropriate manner. So take that, public schools. Ha ha! There's a lot more in freedom of expression that I want to talk about, or freedom of free exercise of religion. Think about the following. Can the state ban a preacher from using live rattlesnakes in his services to protect citizens? Can you make a claim of that mandatory public education after age of say 16 violates your religion, if it truly really does? Can I slaughter a goat if and not get charged with animal cruelty in order to pursue my religious beliefs? How about my son? Can I slaughter him in the same way? So think about those questions for class for us. Let's move on to freedom of expression. So perhaps the most frequently invoked freedom that Americans have, and the one that they talk about the most, is the right to free speech and a free press without government interference. We all believe that we have the right to have our say. Some of us say more than others, and all of us have the right to hear what others have to say. Some of us have to hear more than others. But for the most part, Americans criticize public officials and their actions without having the fear of reprisal of any branch of government. We don't worry about the secret police knocking on our door and dragging us away in the middle of the night. Now, restraining an action or an activity before that activity has actually occurred is called prior restraint. And when expression is involved, prior restraint would really mean censorship as opposed to a subsequent punishment. Prior restraint of expression would require, for example, that a permit be obtained before a speech could be made, a newspaper published, or a movie or a TV show shown. One of the most famous cases concerning prior restraint was New York Times versus United States, which you see on the screen in front of you, the so-called Pentagon Papers case. In 1971, the New York Times and the Washington Post were about to publish the Pentagon Papers, an elaborate secret history of the U.S. government's involvement in the Vietnam War. The secret documents have been obtained illegally by a disillusioned former Pentagon official. The government wanted a court order to bar publication of the documents, arguing that national security was threatened and that the documents had been stolen. The newspapers argued that the public had a right to know the information contained in the papers and that the press had the right to inform the public. The Supreme Court ruled 6-3 in favor of the newspapers' right to publish the information, and this case affirmed the idea of the no prior restraint doctrine. But not all expression is in words or in writing. Articles of clothing, gestures, movement, and other forms of nonverbal expressive conduct are considered symbolic speech. Such speech is given substantial protection today by our courts. For example, in the landmark decision issued in 1969 of Tinker versus Des Moines School District, the United States Supreme Court held that the wearing of black armbands by students in protest against the Vietnam War was a form of speech protected by the First Amendment. The case arose after a school administrator in Des Moines, Iowa, issued a regulation prohibiting students in the Des Moines School District from wearing the armbands. The Supreme Court reasoned that the school district was unable to show that the wearing of the armbands had disrupted normal school activities. Furthermore, the school district's policy was discriminatory as it banned only certain forms of symbolic speech, aka the black armbands, and not others such as lapel crosses and fraternity rings. In 1989, in Texas versus Johnson, the Supreme Court ruled that state laws that prohibited the burning of the American flag as part of a peaceful protest also violated the freedom of expression protected by the First Amendment. Congress responded by passing the Flag Protection Act of 1989, which was ruled unconstitutional by the Supreme Court in 1990. Congress and President George H.W. Bush immediately pledged to work for a constitutional amendment to protect our flag because, there is a host of flag burners out there who are just burning every American flag that they can find. But an effort that has yet to be successful. But in 2003, however, the Supreme Court did hold that a Virginia statute prohibiting the burning of a cross with an intent to intimidate did not violate the First Amendment. The court concluded that a burning cross is an instrument of racial terror so threatening that it overshadows free speech concerns. Commercial speech, though, is usually defined as advertising statements. Can advertisers then use the First Amendment rights to prevent restrictions on the content of commercial advertising? Until the 1970s, though, the Supreme Court had held that such speech was not protected at all by the First Amendment. But by the mid-1970s, more and more commercial speech had been brought under the First Amendment's protection. According to Justice Harry Blackmun, quote, advertising, however tasteless and excessive it sometimes may seem, is nonetheless dissemination of information as to who is producing and selling what product for what reason and at what price, end quote. That was from Virginia State Board of Pharmacy versus Virginia Citizens Consumer Council in 1976. Nevertheless, the Supreme Court will consider a restriction on commercial speech valid as long as it, 1, seeks to implement a substantial government interest, 2, directly advances that interest, and 3, goes no further than necessary to accomplish its objective. In particular, a business engaging in commercial speech can be subject to liability for factual inaccuracies in ways that do not apply to non-commercial speech. At various times, restrictions on expression, though, have been permitted. Let's go through some of these restrictions. The first is clear and present danger. When a person's remarks create a clear and present danger to the peace or public order, they can be curtailed constitutionally. Justice Oliver Wendell Holmes used this reasoning in 1919 when examining the case of a socialist who had been convicted for violating the Espionage Act by distributing a leaflet that opposed the military draft. Holmes stated the following: the question in every case is whether the words are used in such circumstances and of such a nature as to create a clear and present danger that they will bring about the substantive evils that Congress has a right to prevent. It is a question of proximity and degree. Schenck versus United States, 1919. According to the clear and present danger test, then, expression may be restricted if evidence exists that such expression would cause a dangerous condition, actual or imminent, that Congress has the power to prevent. Commenting on this test, Justice Louis Brandeis in 1920 said, quote, "Correctly applied, it will reserve the right of free speech from suppression by tyrannous, well-meaning majorities, and from abuse by irresponsible, fanatical minorities," end quote. Here we're talking about the idea of sedition. So we're talking about overthrowing, the attempted overthrow of the government, which the government has the right to try to prevent. Now, over the course of the 20th century, the United States Supreme Court has modified the clear and present danger rule, limiting the constitutional protection of free speech in 1925 and 1951, and then broadening it substantially in 1969. In Gitlow versus New York, the court introduced the bad tendency test. According to this rule, speech or other First Amendment freedoms may be curtailed if there's a possibility that such expression might lead to some evil. In the Gitlow case, a member of a left-wing group was convicted of violating New York State's criminal anarchy statute when he published and distributed a pamphlet urging the violent overthrow of the United States government. In its majority opinion, the Supreme Court held that although the First Amendment afforded protection against state incursions on freedom of expression, Gitlow could be punished legally in this particular instance because his expression would tend to bring about the evils that the state had a right to prevent. The Supreme Court again modified the clear and present danger test in a 1951 case called Dennis versus United States. At the time, there was a considerable tension between the United States and the Soviet Union, a communist-ruled country including Russia and several other modern-day nations. 12 members of the American Communist Party, of which you see what's called the Dennis 12 on the screen there, of which there's really only 11 pictured, were convicted of violating a statute that made it a crime to conspire to teach, advocate, or organize the violent overthrow of the government in the United States. The Supreme Court affirmed the convictions, significantly modifying the clear and present danger test in the process. The court applied a grave and probable danger rule. Under this rule, the gravity of the evil, discounted by its improbability, justifies such invasion of free speech as is necessary to avoid the danger. This rule gave much less protection to free speech than did the clear and present danger test. But some claim that the United States did not achieve true freedom of political speech until 1969. In that year, in Brandenburg versus Ohio, the Supreme Court overturned the conviction of a Ku Klux Klan leader for violating a state statute. The statute prohibited anyone from advocate, quote, the duty, necessity, or propriety of sabotage, violence, or unlawful methods of terrorism as a means of accomplishing industrial or political reform, end quote. The court held that the guarantee of free speech does not permit a state to, quote, forbid or prescribe advocacy of the use of force or of law violation except where such advocacy is directed to inciting or producing imminent lawless actions and is likely to incite or produce such action, end quote. The incitement test, or direct incitement test, enunciated by the court in this case is a difficult one for prosecutors to meet. And so as a result, the court's decision significantly broadened the protections given to advocacy speech. So now let's look at obscenities. We get to talk about cuss words. Woohoo! All right. A large number of state and federal statutes do make it a crime to disseminate obscene materials. Generally, the courts have not been willing to extend constitutional protections of free speech to what they consider to be obscene materials or obscene words. But what is obscenity? Justice Potter Stewart, who you see on the screen there, once stated in Jacobellis versus Ohio, a 1964 case, that even though he could not define obscenity, quote, I know it when I see it, end quote. The problem, of course, is that even if it were agreed upon, the definition of obscenity changed with time. Victorians deeply disapproved of the loose morals of the Elizabethan age. The works of Mark Twain and Edgar Rice Burroughs at times have been considered obscene. After all, Tarzan and Jane, they weren't legally wedded when they were swinging through the jungles. So we got some definitional problems here. The Supreme Court has grappled from time to time with the difficulty of applying an operationally effective definition of obscenity. In 1973, in Miller versus California, Chief Justice Warren Burger created a formal list of requirements that must be met for material to be legally obscene. Material is obscene if the average person finds that it violates contemporary community standards, the work taken as a whole appeals to a prudent interest in sex, the work shows patently offensive sexual conduct, guys, calm down, right? And the work lacks serious, redeeming literary, artistic, political, or scientific merit. We call that the LAPS test. So literary, artistic, political, or scientific value. The problem, of course, with this is that one person's prudent interest is another person's medical interest, or another person's artistic pleasure. Ooh. The court went on to state that the definition of prudent interest would be determined by the community standard. So what's obscene in Nottoway County would be probably pretty mild in New York City. The court avoided presenting a definition of obscenity, though, leaving this determination to local and state authorities. Consequently, the Miller case has been applied in a very widely inconsistent manner. The Supreme Court has upheld state laws, though, making it illegal to sell materials showing sexual performances by minors. In 1990, in Osborne v. Ohio, the court ruled that states can outlaw the possession of child pornography in the home. The court reasoned that the ban on private possession is justified because owning the material perpetuates commercial demand for it and the exploitation of the children involved. At the federal level, the Child Protection Act of 1984 made it a crime to receive knowingly through the mail sexually explicit depictions of children. Now, a significant problem facing Americans and their lawmakers today is how to control obscenity and child pornography that are disseminated by way of the internet. In 1996, Congress first attempted to protect minors from pornographic materials on the internet by passing the Communications Decency Act, or the CDA. This act made it a crime to make available to minors online any obscene or indecent message that depicts or describes in terms patently offensive as measured by contemporary community standards, sexual or excretory activities or organs. But the act was immediately challenged in court as an unconstitutional infringement on free speech. The Supreme Court held that the act imposed unconstitutional restraints on free speech and was therefore invalid. In the eyes of the court, the term indecent and patently offensive covered too large amounts of non-pornographic material with serious educational or other value. So in a second attempt to protect children from online obscenities, the Child Online Protection Act, or the COPA Act of 1998, also met with a similar fate. Although COPA was more narrowly tailored than its predecessor, the CDA, it still used contemporary community standards to define what material was obscene and harmful to minors. Ultimately, in 2004, the Supreme Court concluded that it was likely that the COPA did violate the right to free speech, and the court prevented enforcement of the act. In 2002, the Supreme Court invalidated a 1996 law banning virtual pornography, which involves only digitally rendered images and no actual children. In 2008, however, the court upheld the legality of a 2003 federal law that made it a crime to offer child pornography, even if the pornography in question doesn't actually exist. In 2000, Congress enacted the Children's Internet Protection Act, or the SEPA, which requires public schools and libraries to install filtering software, hey iBoss, to prevent children from viewing websites with adult content. The SEPA was also challenged on constitutional grounds, but in 2003 the Supreme Court held that the act did not violate the First Amendment. Court concluded that because libraries can disable the filters for any patron to ask, the system does not burden free speech to an unconstitutional extent. All right, let's shift gears a little bit, talk about slander and libel. More slander at this part, we'll get libel later. Now, can you say anything you want to about someone else? Not really. Individuals are protected from what's called defamation of character, which is defined as wrongfully hurting a person's good reputation. The law imposes a general duty on all persons to refrain from making false, defamatory statements about others. Breaching this duty orally is the wrong duty called slander. Breaching it in writing is the wrongdoing called libel, which I'll discuss a little bit later. The government itself does not bring charges of slander or libel. Rather, the defamed person has to bring a civil suit for damages. Legally, slander is the public uttering of a false statement that harms the good reputation of another person. Slanderous public uttering means that the defamatory statements are made to or within the hearing of persons other than the defamed party. If one person calls another dishonest, manipulative, and incompetent to his or her face when no one else is around, that doesn't constitute slander. The message is not communicated to a third party. If, however, a third party accidentally overhears the defamatory statements, the courts have generally held that this constitutes a public uttering and therefore slander, which is prohibited and not protected by the First Amendment. In recent years, high school and university students at public institutions have faced a variety of free speech challenges. Court rulings on these issues have varied by a level of the speech involved. Elementary schools in particular have great latitude in determining what kinds of speech are appropriate for their students. High school students have greater free speech rights, and college students have the most rights of all. High schools can impose restrictions on speech that would not be allowed in a college setting or in the general society. Excuse me, my notes were messed up there. For example, high school officials may censor publications such as newspapers and yearbooks produced by the school's students. Courts have argued that a school newspaper is an extension of the school's educational mission and thus subject to control by the school's administration. One of the most striking rulings to illustrate the power of school officials was handed down by the United States Supreme Court in 2007. An Alaska high school student had displayed a banner reading "Bong Hits for Jesus" on private property across from the school as students on the school grounds watched the Winter Olympics torch relay. The school principal crossed the street, seized the banner, and suspended the student from school. The Supreme Court later held that the school had an important and indeed perhaps compelling interest in combating drug use that allowed it to suppress the banner, and the court's decision here was widely criticized. At the college level, one speech issue is whether a student should have to subsidize, through student activity fees, organizations that promote causes that the student finds objectionable. In 2000, this question came before the Supreme Court in a case brought by several University of Wisconsin students. The students argued that their mandatory student activity fees, which helped to fund liberal causes which they disagreed with, including gay rights, violated their First Amendment rights of free speech, free association, and free exercise of religion. They contended that they should have the right to choose whether to fund organizations that promoted political and ideological views that were offensive to their own political and personal beliefs. To the surprise of many, the Supreme Court rejected the students' claims and ruled in favor of the university. The court stated, quote, "The university may determine that its mission is well served if students have the means to engage in dynamic discussions of philosophical, religious, scientific, social, and political subjects in their extracurricular life. If the university reaches these conclusions, it is entitled to impose a mandatory fee to sustain an open dialogue to these ends." End quote. Board of Regents of the University of Wisconsin System versus Southworth, 2000. Another free speech issue is the legitimacy of campus speech and behavior codes. Some universities have established codes that challenge the boundaries of the protection of free speech provided by the First Amendment. These codes are designed to prohibit so-called hate speech, abusive speech attacking persons on the basis of their ethnicity, race, or other criteria. For example, a University of Michigan code banned, quote, "any behavior, verbal or physical, that stigmatizes or victimizes an individual on the basis of race, ethnicity, religion, sex, sexual orientation, creed, national origin, ancestry, age, marital status, handicap, or Vietnam veteran status." A federal court found that the code violated students' First Amendment rights. Although the courts generally have held, as in the University of Michigan case, that campus speech codes are unconstitutional restrictions on the right to free speech, such codes continue to exist. Whether hostile speech should be banned on high school campuses has also become an issue. In view of school shootings and other violent behavior in the public school system, school officials have become concerned about speech that consists of veiled threats or that could lead to violence. Some schools have even prohibited students from wearing T-shirts bearing some verbal messages, such as sexist or racist comments, or symbolic messages, such as the Confederate flag, that might generate ill will or hatred. Defenders of campus speech codes argue that they are necessary not only to prevent violence, but also to promote equality among different cultural, ethnic, and racial groups on campus, and greater sensitivity to the needs and feelings of other people. Most educators acknowledge that a certain degree of civility is required for productive campus discourse. Moreover, some hostile speech can rise to the level of illegal threats or a legal form of harassment. A number of students also support restraints on campus hate speech. In 2002, for example, the Student Assembly at Wesleyan University passed a resolution declaring that, quote, "right to speech comes with implicit responsibilities to respect community standards," end quote. Extreme hate speech appears on the internet, including racist materials and denial of the Holocaust, the murder of millions of Jews by Nazis during World War II. Can the federal government restrict this type of speech? Or even should it? Consider that even if Congress succeeded in passing a law prohibiting particular speech on the internet, an army of internet watchers would then be needed to enforce it. Also, what if other countries attempt to impose on U.S. websites their laws that restrict speech? Believe it or not, this is not a theoretical issue. In 2000, a French court found the Yahoo company in violation of French laws that banned the display of Nazi memorabilia. In 2001, however, a U.S. federal district court held that this ruling could not be enforced against Yahoo in the United States. Now, freedom of the press can be regarded as a special instance of freedom of speech. Of course, at the time of the framing of the Constitution, the press meant only newspapers, magazines, and books. As technology has modified the ways in which we disseminate information, the laws touching on freedom of the press have been modified. What can and cannot be printed still occupies an important place in constitutional law, however. Libel is the defamation in writing or in pictures, signs, films, or any other communication that has the potentially harmful qualities of written or printed words. As with slander, libel occurs only if the defamatory statements are observed by a third party. If one person writes a private letter to another wrongfully accusing him or her of embezzling funds, that does not constitute libel. It is interesting that the courts have generally held that dictating a letter to a secretary constitutes communication of the letter's content to a third party, and therefore, if defamation has occurred, the wrongdoer then can be sued. A 1964 case, New York Times versus Sullivan, explored an important question regarding libelous statements made about public officials. The Supreme Court held that only when a statement against a public official was made with actual malice, that is, with either knowledge of its falsity or a reckless disregard for the truth, could damages be obtained. The standard set by the court in the New York Times case has since been applied to public figures generally. Public figures include not only public officials, but also public employees who exercise substantial government power, and any persons, such as movie stars, who are generally in the public limelight. Statements made about public figures, especially when they are made through a public medium, usually are related to matters of general public interest. They are made about people who substantially affect all of us. Furthermore, public figures generally have some access to a public medium for answering disparaging falsehoods about themselves, where private individuals really don't. For these reasons, public figures have a greater burden of proof in defamation cases than do private individuals. They must prove that the statements were made with actual malice. Another major issue relating to freedom of the press concerns media coverage of criminal trials. The Sixth Amendment to the Constitution guarantees the right of criminal suspects to a fair trial. In other words, the accused have rights, which we'll talk about in a little bit. The First Amendment guarantees freedom of the press. What if these two rights appear to be in conflict? Which one prevails? Jurors certainly may be influenced by the reading of news stories about the trial in which they are participating in. In the 1970s, judges increasingly issued gag orders, orders that restricted the publication of news about a trial in progress or even a pre-trial hearing to protect the accused's right of a fair trial. In the landmark 1976 case Nebraska Press Association versus Stewart, the Supreme Court unanimously ruled that a Nebraska judge's gag order had violated the First Amendment's guarantee of freedom of the press. Chief Justice Warren Burger indicated that even persuasive adverse pretrial publicity did not necessarily lead to an unfair trial, and that prior restraint on publications was not justified. Some justices even went so far as to suggest that gag orders are never justified. Now, in spite of the Nebraska Press Association ruling, the court has upheld certain types of gag orders. In Gannett Company versus De Pasquale in 1979, for example, the High Court held that if a judge found a reasonable probability that news publicity would harm a defendant's right to a fair trial, the court could impose a gag rule. Quote, members of the public have no constitutional right under the 6th and 14th Amendment to attend criminal trials of which they are not a party to. End quote. The Nebraska and Gannett cases, however, involve pre-trial hearings. Could a judge impose a gag order on an entire trial, including the pretrial hearings? In 1980, in Richmond Newspapers versus Virginia, the court ruled that the actual trials must be open to the public except under unusual circumstances. Now, as we have noted, in only a few cases has the Supreme Court upheld prior restraint of published materials. The court's reluctance to accept prior restraint is less evident with respect to motion pictures. In the first half of the 20th century, films were routinely submitted to local censorship boards. In 1968, the Supreme Court ruled that a film can be banned only under a law that provides for a prompt hearing at which the film is shown to be obscene. Today, few local censorship boards actually even exist. Today, the film industry regulates itself primarily through the industry's rating system. Radio and television broadcasting has the least First Amendment protection. Broadcasting initially received less protection than the printed media because at the time, the number of airwave frequencies was highly limited. In 1934, the national government established the Federal Communications Commission, or the FCC, to regulate electromagnetic wave frequencies. No one has a right to use the airwaves without a license granted by the FCC. The FCC grants licenses for limited periods and imposes a variety of regulations on broadcasting. For example, the FCC can impose sanctions on radio or TV stations that broadcast filthy words, even if the words are not legally obscene. And you can see some information below about a famous case called FCC versus Pacifica Foundation, in which they broadcast George Carlin's famous "The 7 Dirty Words That You Can't Say on Television or Radio" monologue. You can look it up for yourself. Now, the First Amendment prohibits Congress from making any law that abridges, quote, the right of the people to peaceably to assemble and to petition the government for a redress of grievances, end quote. Inherent in such a right is the ability of private citizens to communicate their ideas on public issues to government officials, as well as to other officials or other individuals. The Supreme Court has often put this freedom on a par with freedom of speech and the freedom of press. Nevertheless, it has allowed municipalities to require permits for parades, sound trucks, and demonstrations so that public officials can control traffic or prevent demonstrators from turning into riots. The freedom to demonstrate has become a major issue, especially recently. In 1977, when the American Nazi Party sought to march through Skokie, Illinois, a largely Jewish suburb where many Holocaust survivors resided, the American Civil Liberties Union defended the Nazis' right to march in spite of its opposition to the Nazi philosophy. The Supreme Court let stand a lower court's ruling that the city of Skokie had violated the Nazis' First Amendment guarantees by denying them a permit to march. Oh, sorry, I'm not quite done with that page. Now, an issue that has surfaced in recent years is whether communities can prevent gang members from gathering together on the streets without violating their right of assembly or associated rights. Although some actions taken by cities to prevent gang members from gathering together or loitering in public places have passed constitutional muster, others haven't. For example, in a 1997 case, the California Supreme Court upheld a lower court's order preventing gang members from appearing in public together. In 1999, however, the United States Supreme Court held that Chicago's anti-loitering ordinance violated the constitutional right to due process of law because, among other things, it left too much power to the police to determine what was loitering and what wasn't. A question for Americans today is whether or not individuals should have the right to assemble online for the purpose of advocating violence against certain groups, such as physicians who perform abortions, or advocating values that are opposed to our democracy, such as terrorism. While some online advocacy groups promote interests that are consistent with American political values, other groups have their goal as the destruction of those values. Whether First Amendment freedoms should be sacrificed by the government's monitoring of internet communications, for example, in the interest of national security is a question that will be debated most likely for generations to come. The one thing to keep in mind with the right to assemble and the right to petition is that the government typically can limit time, place, and manner, but they cannot limit what is going to be said there. They must be content neutral. Now, no explicit reference is made anywhere in the Constitution to a person's right to privacy. Until the second half of the 1900s, the courts did not take a very positive approach toward the right to privacy at all. For example, during Prohibition, suspected bootleggers' telephones were tapped routinely, and the information obtained was often used as a legal basis for prosecution. In Olmstead versus the United States in 1928, the Supreme Court upheld such invasion of privacy. Justice Louis Brandeis, a champion of personal freedoms, strongly dissented from the majority in this case. He argued that the framers of the Constitution gave every citizen the right to be left alone. He called such a right, quote, the most comprehensive of rights and the right most valued by civilized men, end quote. In the 1960s, the highest court began to modify the majority view. In 1965, in Griswold versus Connecticut, the Supreme Court overturned a Connecticut law that effectively prohibited the use of contraceptives, holding that the law violated the right to privacy. Justice William Douglas formulated a unique way of reading this right into the Bill of Rights. He claimed that the First, Third, Fourth, Fifth, and Ninth Amendments created penumbras or shadows formed by emanations sent out from those guarantees that help give them life and substance. And he went on to describe zones of privacy that are guaranteed by these rights. When we read the Ninth Amendment, we can see that the foundation for his reading comes from this, quote, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people, end quote. In other words, just because the Constitution, including its amendments, does not specifically talk about the right to privacy, doesn't mean that this right is denied to the people. Some of today's most controversial issues relate to privacy rights. One issue involves the erosion of privacy rights in an information age, as computers makes it easy to compile and distribute personal information. Other issues concern abortion and the right to die. Since 9/11, Americans have faced another crucial question regarding privacy rights. To what extent do we sacrifice privacy in the interest of national security? Now, an important issue created by new technology is the amassing of information on individuals by both government agencies and by private businesses such as marketing firms. Private information on the average American citizen is filed away in dozens of agencies: Social Security, Internal Revenue Service, Medicare and Medicaid, and so forth. Because of the threat of indiscriminate use of this private information by unauthorized individuals, Congress did pass the Privacy Act in 1974. This was the first law regulating the use of federal government information about private individuals. Under the Privacy Act, every citizen has the right to obtain copies of personal records collected by federal agencies to correct inaccuracies in such records. The ease with which personal information can be obtained by using the internet for marketing and other purposes has led to a unique privacy issue. Some fear that privacy rights and personal information may soon be a thing of the past. Whether privacy rights can survive in an information age, though, is a question that Americans continue to confront on a regular basis. Now, historically, abortion was not a criminal offense before the quickening of the fetus, and that was the first movement of the fetus in the uterus, usually between the 16th and 18th weeks of pregnancy. During the last half of the 19th century, however, state laws became much more severe. By 1973, performing an abortion at any time during pregnancy was a criminal offense in a majority of states. In 1973, in Roe v. Wade, the United States Supreme Court accepted the argument that the laws against abortion violated, quote, Jane Roe, and that was her pseudonym that she used, not her real name, violated her right to privacy under the Constitution. The court held that during the first trimester, the first 3 months of pregnancy, abortion was an issue solely between the woman and her physician. The state could not limit abortions except to require that they be performed by a licensed physician. During the second trimester, to protect the health of the mother, the state was allowed to specify the conditions under which an abortion could be performed. And during the final trimester, the state could regulate or even outlaw abortions except when necessary to preserve the life or health of the mother. Now, after the Roe case, the Supreme Court issued a number of decisions in cases defining and redefining the boundaries of state regulation and abortion. During the 1980s, the court twice struck down laws that required a woman who wished to have an abortion to undergo counseling designed to discourage the abortion. In the late 1980s and early 1990s, however, the court took a more conservative approach. For example, in Webster versus Reproductive Health Services in 1989, the court upheld a Missouri law that, among other things, banned the use of public hospitals or other taxpayer-supported facilities for performing abortions. And in Planned Parenthood versus Casey in 1992, the court upheld a Pennsylvania law that required pre-abortion counseling, a waiting period of 24 hours, and for girls under the age of 18, parental or judicial permission. As a result, abortions are now becoming more difficult to obtain in some states than others. Abortion continues to be a divisive issue, though. Right to Life groups continue to push for laws that ban abortion. They continue to endorse political candidates who support their views and to organize protests. Because of several episodes of violence attending protests at abortion clinics, in 1994 Congress passed the Freedom of Access to Clinics Entrance Act. The act prohibited protesters from blocking entrance to such clinics. The Supreme Court ruled in 1993 that such protesters can be prosecuted under laws governing racketeering, and in 1998 a federal court in Illinois convicted Right to Life protesters under these laws. In 2006, however, the Supreme Court unanimously reversed its earlier decision that Right to Life protesters could be prosecuted under laws governing racketeering. In 1997, the Supreme Court upheld the constitutionality of prohibiting protesters from entering a 15-foot buffer zone around abortion clinics and from giving unwanted counseling to those entering the clinics. In a 2000 decision, the court upheld a Colorado law requiring demonstrators to stay at least 8 feet away from people entering and leaving clinics unless people consented to be approached. The court concluded that the law's restrictions on speech-related conduct did not violate the free speech rights of abortion protesters. Now, another issue in the abortion controversy concerns partial birth abortion. A partial birth abortion, which physicians call intact dilation and extraction, is a procedure that can be used during the second trimester of pregnancy. Abortion rights advocates claim that in limited circumstances, the procedure is the safest way to perform an abortion, and that the government should never outlaw specific medical procedures. Opponents argue that the procedure has no medical merit and that it ends the life of a fetus that might be able to live outside of the womb. In 2000, the Supreme Court addressed this issue when it reviewed a Nebraska law that banned partial birth abortions. Similar laws have been passed by at least 27 of the 50 states. The court invalidated the Nebraska law on the ground that, as written, the law could be used to ban other abortion procedures and contained no provision for protecting the health of the pregnant woman. In 2007, the Supreme Court revisited this issue of a partial birth abortion when it reviewed 2 cases involving a 2003 federal law similar to the Nebraska statute. In 2007, however, in a 5-4 vote, the Supreme Court upheld the federal law. The court stated that the opponents of the act have not demonstrated that the act would be unconstitutional in a large fraction of relevant cases. Furthermore, said the court, quote, government has a legitimate and substantial interest in preserving and promoting fetal life, end quote. The court also noted that there was an alternative, although less safe according to the act's opponents, abortion procedure that could be used in the second trimester. Also, the court emphasized that the law allowed partial birth abortion to be performed when a woman's life was in jeopardy. Note that the court's 2007 ruling concerned how abortions could be effected, not whether or not abortions were legal, which was the central issue in Roe v. Wade. The court emphasized this by stating that although the government may not forbid abortion altogether, it, quote, may use its voice and its regulatory opinion to dissuade women from ending their pregnancy, end quote. In her dissent to the majority, Justice Ruth Bader Ginsburg said that the ruling, quote, cannot be understood as anything other than an effort to chip away at a right declared again and again by this court, end quote. And that's right, is the woman's right to choose. Now let's shift gears just a little bit. We're still in privacy, and let's look at privacy and the right to die. A 1976 case involving Karen Ann Quinlan was one of the first publicized right to die cases. The parents of Quinlan, a young woman who had been in a coma for nearly a year and had been kept alive at that time by a respirator, wanted her respirator removed. And in 1976, the New Jersey Supreme Court ruled that the right to privacy included the right of a patient to refuse treatment, and that patients unable to speak can exercise that right through a family member or guardian. In 1990, the Supreme Court took up this issue. In Cruzen versus Director of Missouri Department of Health, the court stated that a patient's life-sustaining treatment can be withdrawn at the request of a family member only if there is clear and convincing evidence that the patient didn't want such treatment in the first place. But what if there's no living will? Since the 1976 Quinlan decision, most states have enacted laws permitting people to designate their wishes concerning life-sustaining procedures in what are called living wills or durable health care powers of attorney. My wife and I both have one. These laws and the Supreme Court Cruzen decision have resolved the right to die controversy for situations in which the patient has drafted a living will. But disputes are still possible if there is no living will present. An example of this is the case of Terry Schiavo, the husband of a Florida woman who had been in a persistent vegetative state and who you see on the right-hand part of the screen, sought to have her feeding tube removed on the basis of oral statements that she would not want her life prolonged in such circumstances. Schiavo's parents fought this move in court, but lost on the ground that a spouse and not a parent is the appropriate legal guardian for a married person. Although the Florida legislature passed a law allowing Governor Jeb Bush to overrule the courts, the state Supreme Court held that the law violated the state constitution. In March of 2005, the U.S. Congress intervened and passed a law allowing Schiavo's case to be heard within the federal court system. The federal courts, however, essentially agreed with the Florida state courts in the first place and refused to order the reconnection of the feeding tube, which had been disconnected a few days earlier. After twice appealing to the United States Supreme Court without success, the parents gave up hope and Schiavo died shortly after. Now, in the 1990s, another issue related to this kind of surfaced. Do privacy rights include the right of terminally ill people to end their lives through physician-assisted suicide? Until 1996, the courts consistently upheld state laws that prohibited this practice, either through specific statutes or under their general homicide statutes. In 1996, after two federal appellate courts ruled that state laws banning assisted suicide in Washington and New York were unconstitutional, the issue reached the United States Supreme Court. In 1997, in Washington versus Glucksberg, the court stated that the liberty interest protected by the Constitution does not include a right to commit suicide with or without assistance. In effect, the Supreme Court left the decision to the states. Since then, assisted suicide has been allowed in only two states, Oregon and Washington. And in 2006, the Supreme Court upheld Oregon's physician-assisted suicide law against a challenge from the Bush administration. As former Supreme Court Justice Thurgood Marshall once said, quote, grave threats to liberty often come in times of urgency when constitutional rights seem too extravagant to endure, as you see here on the screen. Not surprisingly, anti-terrorist legislation since the attacks on September 11th have eroded certain basic rights, in particular the Fourth Amendment protections against unreasonable searches and seizures. Current legislation allows the government to conduct what are called roving wiretaps. Previously, roving wiretaps could be requested only for persons suspected of one of a small number of serious crimes. Now, if persons are suspected of planning a terrorist attack, they can be monitored no matter what form of electronic communication they use. Such roving wiretaps contravene the Supreme Court's interpretation of the Fourth Amendment, which requires a judicial warrant to describe the place which is to be searched, not just the person. One of the goals of the framers was to avoid general searches. Further, once a judge approves an application for a roving wiretap, when, how, and where the monitoring occurs will be left to the discretion of the law enforcement agents. Supporters of these new procedures say that they allow agents to monitor individuals as they move about the nation. Previously, a warrant issued in one federal district might not be valid in another. Much of the government's failure to anticipate the attacks of September 11th, though, has been attributed to a lack of cooperation among government agencies. At that time, barriers prevented information sharing between law enforcement and intelligence arms of the government. Lawmakers claimed that the USA Patriot Act of 2001 would improve lines of communication between agencies, such as the Federal Bureau of Investigation, or the FBI, and the Central Intelligence Agency, or the CIA, allowing the government to better anticipate terrorist plots. In addition, the Patriot Act eased restrictions on the government's ability to investigate and arrest suspected terrorists. Because of the secretive nature of terrorist groups, supporters of the Patriot Act argue that the government must have greater latitude in pursuing leads on potential terrorist activity. The Act authorizes law enforcement officials to secretly search a suspected terrorist home. It also allows the government to monitor a suspect's internet activities, phone conversations, financial records, and book purchases. For the first time in American history, the government now can even open a suspect's mail. Although a number of these search and surveillance tactics have long been a part of criminal investigations, the Patriot Act expanded their scope and streamlined the process of obtaining warrants to use them. Now, proponents of the Patriot Act insist that ordinary law-abiding citizens have nothing to fear from the government's increased search and surveillance powers. Groups such as the American Civil Liberties Union, though, have objected to the Patriot Act, however, arguing that it poses a grave threat to constitutionally guaranteed rights and liberties. Under the Patriot Act, FBI agents are required to certify the need for search warrants to the court, but the court cannot, in fact, reject the request for a warrant. The Patriot Act also authorized national security letters, or NSLs, which are subpoenas issued by the FBI itself and which do not require probable cause or judicial oversight. In addition, an individual or financial institution that is served with such a warrant cannot speak about the government's investigation to anyone. Thus, many argue that this provision of the Patriot Act contradicts the First Amendment by making free speech a crime. In addition to the First Amendment issues, this provision raises the concern that no one would be allowed to blow the whistle on abuses of government power. As a result of these concerns, a U.S. District Court found the NSL provisions of the Patriot Act to be unconstitutional in 2004 and then again in 2007. Finally, if the government decides to take a suspected terrorist into custody, the suspect can be summarily denied bail, a breach of the Eighth Amendment. Opponents of the Patriot Act fear that if these expanded powers of investigation might be used to silence government critics or to threaten members of interest groups who oppose government policies today, they also could be used in the future. Congress debated all of these issues in 2005 and then renewed almost all of the provisions of the Act in 2006. It is certainly true that the government has used the Patriot Act to develop cases that have almost nothing to do with terrorism. For example, the Patriot Act was used to develop a case against New York Governor Eliot Spitzer and his use of prostitutes. Not exactly an act of terrorism. Shortly after 9/11, President George W. Bush issued an executive order authorizing the National Security Agency to conduct secret surveillance. The NSA was ordered to monitor without obtaining warrants, phone calls, or other communications between foreign parties and persons within the United States when one of the parties had suspected links to a terrorist organization. When the American public learned of this secret program in December of 2005, the news led to intense criticism by civil rights groups. These groups and other Americans called for the immediate termination of the alleged illegal surveillance. Now, in 2007, Congress passed a law to authorize the warrantless NSA wiretaps. The law expired in 2008, however, and its reauthorization was held up by a dispute between Congress and the Bush administration as to whether telephone companies should receive blanket immunity from lawsuits stemming from their past cooperation with the wiretaps. President Bush threatened to veto any reauthorization that didn't grant the immunity, and as of today, the courts have not yet ruled on the constitutionality of these warrantless wiretaps. Two courts have said they were unconstitutional, while one has said that they were not, or they were constitutional.
All right, so let's look at rights of the accused now. So we'll kind of shift gears from rights of the individuals and take a look at rights of the accused. Make sure I get my microphone off here. Now, the United States has one of the highest murder rates in the entire industrialized world. But it's not surprising, therefore, that many citizens have extremely strong opinions about the rights of those accused of violent crimes. When an accused person, especially one who has confessed to some sort of criminal act, is set free because of an apparent legal technicality, many people believe that the rights of the accused are being given more weight than the rights of society and of potential or actual victims. Why then give criminal suspects rights? The answer is partly to avoid convicting innocent people, but mostly because due process of law and fair treatment benefit everyone who comes in contact with law enforcement or the courts. The courts and the police must constantly engage in a balancing act of competing rights. At the basis of all discussions about the appropriate balance is, of course, the United States Bill of Rights. The 4th, 5th, 6th, and 8th Amendments deal specifically with the rights of criminal defendants. The basic rights of criminal defendants are outlined in this next slide. When appropriate, the specific constitutional provision or amendment on which a right is based is also given for you. This is an important slide, and you should try to not memorize it, but at least familiarize yourself with it. So the first part here is limits on the conduct of police officers and prosecutors. Bill of Rights prohibits no unreasonable or unwarranted searches or seizures in the 4th Amendment, as well as no arrest except on cases of probable cause. No coerced confessions or illegal interrogations in the 5th Amendment. No entrapment, and upon questioning, a suspect must be informed of their rights in the 5th and 6th Amendments. A defendant's pretrial rights would include the right of writ of habeas corpus in Article 1 of Section 9, prompt arraignment in Amendment 6, legal counsel in Amendment 6, reasonable bail in Amendment 8, to be informed of charges in Amendment 6, and to remain silent in the 5th Amendment. Trial rights would include speedy and public trial before a jury in the Sixth Amendment, impartial jury selected from a cross-section of the community, an atmosphere free of prejudice, fear, and outside interference, no compulsory self-incrimination in the Fifth Amendment, adequate legal counsel in the Sixth Amendment, no cruel and unusual punishment in the Eighth Amendment, the opportunity to appeal a conviction, but not necessarily to have that appeal heard, or at least definitively given another trial, let me put it that way, and no double jeopardy in the Fifth Amendment. Let's shrink that down here and change this to $1.25. There we go. Now, during the 1960s, the Supreme Court, under Chief Justice Earl Warren, significantly expanded the rights of accused persons. In Gideon versus Wainwright, a case decided in 1963, the court held that if a person is accused of a felony and cannot afford an attorney must be made available to the accused person at government expense. Although the Sixth Amendment to the Constitution provides for the right to counsel, the Supreme Court had established a precedent 21 years earlier in Betts versus Brady, when it held that only criminal defendants in capital or death penalty cases automatically had a right to legal counsel. But during the 1960s and 1966, the court issued its decision in Miranda versus Arizona. The case involved Ernesto Miranda. Full screen this. Oh, no, I don't want to do that. I wanted to do entire page. Sorry about that. And Mr. Miranda was arrested and charged with the kidnapping and rape of a young woman. After 2 hours of questioning, Miranda confessed and was later convicted. Miranda's lawyer appealed his conviction, arguing that the police had never informed Miranda that he had a right to remain silent and a right to be represented by counsel. The court, in ruling in Miranda's favor, enunciated the Miranda rights that are now familiar to almost all of us and that you see on the screen in front of you. Prior to any questioning, the person must be warned that he or she has a right to remain silent, that any statement they make may be used against them, and that they have a right to the presence of an attorney, either retained or appointed, and they can decide at any time to exercise these rights and not answer any questions or make any statements. Provision in a law passed by Congress in 1968 reinstated a rule that had been in effect for 180 years before Miranda, that statements by defendants can be used against them if the statements were voluntarily made. The Justice Department, though, refused to enforce the provision, however, and in 2000 the Supreme Court held that the Miranda warnings were constitutionally based and could not be overruled by legislative act. Now, as a part of a continuing attempt to balance the right of accused persons against the rights of society, the Supreme Court has made a number of exceptions to Miranda. In 1984, for example, the court recognized a public safety exception to the rule. The need to protect the public warranted the admissibility of statements made by the defendant, in this particular case indicating where he had placed a gun, as evidence in a trial, even though the defendant had not been informed of his Miranda rights. In 1985, the court further held that a confession need not be excluded even though the police failed to inform a suspect in custody that his attorney had tried to reach him by telephone. And in an important 1991 decision, the court stated that a suspect's conviction will not be automatically overturned if the suspect was coerced into making a confession. If the other evidence admitted at trial is strong enough to justify the conviction without the confession, then the fact that the confession was obtained illegally, in effect, can be ignored. In yet another case in 1994, the the Supreme Court ruled that suspects must unequivocally and assertively state their right to counsel in order to stop police questioning, saying, maybe I should talk to a lawyer during an investigation after being taken into custody is not enough. The court held that police officers are not required to decipher the suspect's intentions in such situations. In other words, you must state, I want to see my lawyer, and not maybe should I see a lawyer, or, an idea that maybe a lawyer is a good idea. In view of the numerous exceptions, there are no guarantees that the Miranda rule will survive indefinitely. Increasingly, though, law enforcement personnel are using digital movie cameras to record interrogations. According to some scholars, the recording of all custodial interrogations would satisfy the Fifth Amendment's prohibition against coercion, and in the process render the Miranda warnings pretty well unnecessary. But others argue, however, that recorded interrogations can be misleading. Now, at least since 1914, judicial policy has prohibited the admission of illegally seized evidence at trial in federal courts. This is what's called the so-called exclusionary rule. Improperly obtained evidence, no matter how telling, cannot be used by prosecutors. This includes evidence obtained by police in violation of a suspect's Miranda rights or of the Fourth Amendment. The Fourth Amendment protects against unreasonable searches and seizures, and provides that a judge may issue a search warrant to a police officer only on probable cause, a demonstration of facts that permit a reasonable belief that a crime has been committed. The courts must determine what constitutes what is unreasonable and what is a reasonable search and seizure. The reasoning behind the exclusionary rule is that it forces police officers to gather evidence properly, in which case their due diligence will be rewarded by a conviction. Nevertheless, the exclusionary rule has always had critics who argue that it permits guilty persons to be freed because of innocent errors. This rule was first extended to state courts proceedings in a 1961 United States Supreme Court decision, Mapp versus Ohio. In this case, the court overturned the conviction of Dollary Mapp for the possession of obscene materials. Police found pornographic books in her apartment after searching it without a warrant, and despite her refusal to let them in. Over the last several decades, the Supreme Court has diminished the scope of the exclusionary rule by creating some exceptions to its applicability. For example, in 1984, the court held that illegally obtained evidence could be admitted at trial if law enforcement personnel could prove that they would have obtained the evidence legally anyway. In another case, a technically incorrect search warrant form to obtain evidence had acted in good faith, and therefore the evidence was admissible at trial. The court thus created the good faith exception to the exclusionary rule. Under the Fourth Amendment, search warrants must describe the person or things to be seized. In addition, however, officers are entitled to seize items not mentioned in the search warrant if the materials are in, quote, plain view, and appear reasonably to be contraband or evidence of a crime. Excuse me, guys. Now let's look at the death penalty. Capital punishment remains one of the most debated aspects in our criminal justice system. Those in favor of the death penalty maintain that it serves as a deterrent to serious crime and satisfies society's needs for justice and fair play. Those opposed to the death penalty do not believe it has any deterrent value at all, and hold that it constitutes a barbaric act in an otherwise civilized society. The Eighth Amendment prohibits cruel and unusual punishment. Throughout history, cruel and unusual referred to punishments that were more serious than the crime itself. The phrase referred to torture and to executions that prolong the agony of dying. The Supreme Court never interpreted cruel and unusual to prohibit all forms of capital punishment in all circumstances. Indeed, a number of states had imposed the death penalty for a variety of crimes and allowed juries to decide when the condemned could be sentenced to death. Many believed, however, that the imposition of the death penalty was random and arbitrary, and in 1972 the Supreme Court agreed in Furman versus Georgia. The Supreme Court's 1972 Furman decision stated that the death penalty as then applied violated the 8th and 14th Amendments. The court ruled that capital punishment is not necessarily cruel and unusual if the criminal has killed or attempted to kill someone. In its opinion, the court invited the states to enact more precise laws so that the death penalty would be applied more consistently. By 1976, 25 states had adopted a two-stage procedure for capital cases. In the first stage, a jury determined the guilt or innocence of the defendant for a crime that has been determined by statute to be punishable by death. If the defendant is found guilty, the jury reconvenes in the second stage and considers all relevant evidence to determine whether the death sentence is in fact warranted. In 1976, in Gregg versus Georgia, the Supreme Court ruled in favor of Georgia's two-stage process, holding that the state's legislative guidelines had removed the ability of a jury to, quote, wantonly and freakishly impose the death penalty, end quote. The court upheld similar procedures in Texas and Florida, establishing a roadmap for all states to follow that would assure them protection from lawsuits based on Eighth Amendment grounds. Today, 37 states, and you can see in the figure above here, and actually let me shrink that down for you so you can see that a little bit more clearly. And the federal government have capital punishment laws based on the guidelines established by the Gregg case. State governments are responsible for almost all executions in this country. The executions of Timothy McVeigh and Juan Raul Garza in 2001 marked the first death sentences carried out by the federal government since 1963. At this time, there are approximately 3,350 prisoners on death row across the nation. The number of executions per year reached a high in 1998 at 98 and then began to fall. Many people believe that the declining number of executions reflects the waning support among Americans for the imposition of the death penalty. In 1994, polls indicated that 80% of Americans supported the death penalty in cases involving murder. But recent polls, however, suggest that this number has dropped to about 65%. The decline in the number of executions may be due in part to the Supreme Court's 2002 ruling in Ring versus Arizona. The court held that only juries, not judges, could impose the death penalty, thus invalidating the laws of 5 states that allowed judges to make this decision. The ruling meant that the death sentences of 168 death row inmates would have to be reconsidered by the relevant courts. The sentences of many of these inmates have been committed to life in prison. And you can see here, if you look down, some facts about death penalty cases in terms of the different states with the death penalty and states that have it and just aren't using it. And you can see here states that are using it the most, including us here in Virginia, and states that have a lot of people on their death row that are not using it. You can see California has the most people on death row with 669. In 1996, Congress passed the Anti-Terrorism and Effective Death Penalty Act. The law limited access to the federal courts for all defendants convicted in state courts. It also imposed a severe time limit on death row appeals. The law requires federal judges to hear these appeals and issue their opinions within a specified time period. Many are concerned that the shortened appeals process increases the possibility that an innocent person or persons may be put to death. Recently, DNA testing has shown that some innocent people may have been convicted unjustly of murder. Since 1973, more than 100 prisoners have been freed from death row after new evidence suggested that they were convicted wrongfully. On average, it takes about 7 years to exonerate someone on death row. Currently, however, the time between conviction and execution has been shortened from an average of 10 to 12 years to an average of 6 to 8 years. So the question is it a matter of have we executed an innocent person, or is it inevitable that we will execute an innocent person? On the final slide here, I've given you some discussion questions for you to think about. One about freedom of speech, one about religious needs for Muslim students, one about religion in the military, one about intelligent design, and one about Miranda. We have a lot of other things that we'll talk about in class. We'll talk about right to lawyers. We'll talk some more about some of these landmark decisions, especially freedom of speech, press, and criminal cases. And we'll do some activities and so forth in class. But this is our picture point on civil liberties, and I'm Mr. L, and I've enjoyed our time together. Bring your questions to class so we can go on over them together. And as always, be excellent.